Okay, calling case prosecutor order number 25-13823. This is the matter of Desmond Omarion Spencer. Detective, you're still under oath. Just state your name and the facts in this matter.
Detective Scott Turner.
Okay.
November 30th, 2025, Officer Barclay and Officer Redburn, who were a double car riding routine patrol, observed a Jeep Grand Cherokee with tinted driver and passenger side windows drive past them on westbound 8 Mile in Oak Park. Officers observed the Jeep had a defective license plate light on the vehicle.
Tint. That's all you need to know right there. Tint in Michigan. I don't know if you guys know this about Michigan, but it's cold. It's really cold.
As they attempted to catch up to the vehicle, the Jeep started to accelerate away from the officers. Officers turned on their fully marked patrol unit lights and sirens, and the vehicle began to flee from officers. The Jeep speeds were at 70 miles per hour in a 40-mile-an-hour posted zone along 8 Mile in Oak Park. At one point during the chase, the Jeep lost control due to the snowy conditions and left the roadway, striking a utility pole in the median of the roadway. The Jeep continued over the median from westbound 8 Mile to eastbound 8 Mile. The vehicle entered the roadway, then continued driving eastbound 8 Mile and disregarded commands from officers to pull over, ignoring their lights and sirens. The Jeep then drove through a solid red light for eastbound 8 Mile traffic at Coolidge. The Jeep then struck a curb, pulling into a parking lot, which time the driver, identified later as Desmond Omarion Spencer, 7/22/2004, jumped out of the Jeep from the driver's seat and began running away from the vehicle. Officer Barclay chased after Spencer, the driver, and gave verbal commands to stop running. Officer Barclay was in her full police uniform. Officer Spencer was able to flee from Officer Barclay at that time. Sergeant Mata was able to locate Spencer in the area from where he fled from Officer Barclay, and a foot pursuit again began. Sergeant Mata was able to catch up to Spencer, where he and Officer McDonald gave verbal commands for Spencer to stop running and that they were the police. Sergeant Mata had to deploy his department-issued taser, striking Spencer with the taser. Officer McDonald and Officer Hall were able to eventually place Spencer into handcuffs. For the reason above, I'm asking you to sign the warrant of fleeing, elude, third degree, and resisting, obstructing a police officer in the performance of their duties.
The court finds that the alleged crimes were committed. Probable cause to believe the defendant committed said offense. Court will sign and issue a complaint and warrant in this matter. Any CCH information that you have that you want to share with the court?
Yes, Your Honor. Mr. Spencer has a CCH, previous flee and elude from 2024. He had just one bound over this October from 36th District to the 3rd District, and he's also awaiting a judicial segment for a resist and obstruct out of Troy of this year.
Thank you very much. Appreciate it.
You're welcome, Your Honor.
I should mention at this point that this is all Zach's fault, with the exception of one I poached from court cam.
Who's the first one, you think?
It should be Mr. Spencer. He was the last one I talked to.
On their house? No, they own a car or something. So they put up something that's collateral.
Well, we'll give you a call. See what happens first. Just saying. Likely you're gonna have it.
Calling case prosecutor order number 2025-13823 in the matter of Desmond Spencer. Counsel appears for the record.
Yes, good morning, Your Honor. Cecilia Carandongo on behalf and with Desmond Spencer for purposes of arraignment only. Mr. Spencer is on Zoom, Your Honor. I'm in the courtroom. And for purposes of arraignment, we would waive reading of the charges, then him mute, ask to grant a not guilty plea on his behalf. He was advised of the nature of the offenses, their maximum possible penalties, as well as provided his basic constitutional and statutory rights.
Okay. Thank you, counsel. Court waiver plea of not guilty on your client's behalf. Court-appointed counsel is also granted in this matter. Mr. Spencer, would you state your full name for the record?
Desmond Omarion Spencer.
Okay, thank you for that, sir. Counsel, would you like to address Bob?
Yes, Your Honor. So as the court heard before during the swear to, Mr. Spencer is on release on some other matters right now. I did explain to him he's not eligible for a personal bond, but I am asking that you consider a low cash bond, perhaps with GPS, supervision. He did secure employment through a temp agency, and he was supposed to go there tomorrow. He does have a release address that's listed on Burwood Street in Detroit. He gave me a valid phone number. He's only 21 years old, Your Honor, so he would be eligible for, some type of suppressed status ultimately. So that's what I'm asking. He is requesting court-appointed counsel, yeah.
Okay, court-appointed counsel is granted, not guilty plea entered as indicated by the court. So before the court gets to bond, Mr. Spencer, I have a few things I want to go over with you. You must personally appear for all your court appearances. Do not leave the state of Michigan without permission of this court. Immediately notify the court in writing if you change your address or phone number. You shall not possess any firearms or other dangerous weapons. You shall not refrain from using alcohol, any form of THC, marijuana, illegal drugs, or using any medication. You must contact pretrial services within 24 hours of your release. That's at the 45th District Court in Oak Park. You will get a copy of everything I'm going over with you. Pick up no new criminal offenses while you're on bond.
Do we have inside information here in the chat?
I have granted court-appointed counsel for you. These are felony matters. So your next court date is your probable cause conference. It is scheduled for December the 8th of 2025, and you have an exam scheduled for December the 15th of 2025. Both these matters are at 9:00 a.m. in the 45th District Court in Oak Park. So far, sir, do you understand your bond conditions?
Yes.
I'm sorry, can you speak a little louder?
Yes.
Okay. Based upon the allegations, and you got some prior things going on. Based upon the allegations, the court considers you somewhat of a danger to the general public. Based upon the allegations, bond will be set in the amount of $5,000 cash surety, no 10%. You're all set, sir. Best of luck to you.
Wait, I got a question. You say it's 5,000 even?
Yes. Yeah.
So what if they don't have the 5,000?
Stand down.
You can try and use a bail bondsman too, Mr. Spencer. It would be less money than that with a bail bondsman.
How can I get a bail bond?
I like the jail officer. He's like, I'll handle this. 5,000? Yeah, it's 5,000. What happens if I don't have it? You sit in jail. Doing everybody a favor.
We'll take care of that, okay?
They'll help you at Oak Park.
Your Honor, I want to say I'm sorry and I apologize to you.
Okay, you're more than welcome, sir. You have a good day now. Be careful, okay?
What is your name, sir?
Fabian Ordaz, boss.
Say it again.
Fabian Ordaz.
Ordaz. Good morning,
Yes,
Mr. Ordaz.
Good morning, boss.
Don't call me boss. I'm not your boss.
Yes, sir.
All right, Mr. Ordaz is.
I hate that too. I hate that crap. It's so disrespectful. It's just so dumb. It assumes a relationship you don't have. You tell him, Judge.
Here on three cases, injury to a child or an elderly individual, assault, family violence, and interference with public duties. Risk assessment level 2. According to the pretrial services report, he has no pending cases. He says he's got no money for bond. Ms. Licona?
Thank you, Judge. Mr. Ordaz is a U.S. citizen.
I should have known
He has
better.
lived in El Paso for his lifetime. He completed high school at Hanks High School. His family lives here. He did indicate $0 to that he has to pay for his bond, and he says he's been working for DoorDash for a couple of years now. We are asking for a reduced bond on this case, Judge.
Thank you. Ms. Hill?
Your Honor, similarly to the case that we previously heard, the residence that the defendant lives at is where the altercation occurred. In this particular case, there's multiple victims. One who was his father, who was 52 years of age. Additionally, I'm not sure if it was his aunt or mother, but another complaining witness who was 52 years of age, as well as his grandmother who was 76 years of age. So in this particular case, officers responded out, the complaining witness who was the grandmother, stating that the defendant was fighting with his father, who's her son. The complaining witness 3, who is the female who is 52 years of age, she attempted to break up the fight and the defendant struck her repeatedly in the chest, causing her pain and discomfort. There were multiple broken items throughout the residence as caused by the defendant. The 76-year-old grandmother stated that the defendant pushed her, causing her to fall back on her back, causing her pain and discomfort. So with the one female, he struck in the chest. The grandmother, he pushed and hurt her back, and then he fought, and it was kind of a mutual combat situation with his father. So,
And Judge, I'm sorry to interrupt.
So based on that, the state would definitely be opposed to him residing at that address, even if they would warrant it, just based on the fact that there are multiple victims there. And so based on
What
those
was the
particular,
interference? What was the interference with public duties about?
So basically that was after they were responded out there. While holding the defendant's left arm, the defendant pulled out of the residence and officers were attempting to gain control with regard to the particular investigation. The officers, it seemed like it was a resisting that turned into an interference. They said the defendant interrupted, impeded, and interfered with his duty to investigate the alleged assault of the multiple bodily injury, family violence cases in the elderly.
Ms. Lacona, you wanted to say something?
Yes, Judge, I was just going to say I missed the comment that said he would be living with his brother at 11100 Seafoam, El Paso, Texas.
Okay. All right. On the injury to an elderly and the assault family violence, I'm going to set his bond at $2,500 with conditions, that is in cash or through a bonding company, intensive level supervision. Mr. Ordaz, you are ordered not to use drugs or alcohol. Stay in contact with the PR bond office and do not commit any further crimes. In addition to that, you are to have absolutely no contact with either complainant. Do you understand?
Sure.
You may not go within 200 yards of their residence. You may not possess any weapons, firearms, or ammunition. On the interference with public duties, I'm going to grant a PR bond under administrative conditions. Don't commit any other crimes and stay in contact with the PR bond office. Do you have any questions?
Upon arrest, it wasn't a proper arrest, so I'd like to see what I can do with that.
Okay, that is something that you'll need to discuss with your lawyer.
You can go ahead and shut your hole. Okay. You attacked your abuela there, Jackwagon. Your argument sucks, and I haven't even heard it yet.
Lawyer, I cannot give you any advice.
Okay.
All right?
I didn't do anything here.
Judge, can you repeat the bonds? I'm sorry, for the assault and the injury to an elderly?
$2,500 cash corporate surety
On each?
on each.
Okay.
Thank you.
For a total of $5,000. Okay. Any other questions, Mr. Ordaz?
No, sir. When would I be able to talk to the lawyer?
More than likely on Monday or Tuesday of this week. All right, sir?
Okay.
Okay. Did you request a court-appointed counsel?
I pleaded not guilty. If that's better, yes.
No, that's not what that means. Okay. When you were brought initially to the jail, you spoke to a judge. They played a recording for you explaining to you what the rights you have under the law. One of the questions that judge asked you is if you are requesting a court-appointed lawyer. Did you tell him yes or did you tell him no?
I told him no.
Okay, do you have money to
Oh,
hire your
wait,
own?
can you repeat that, boss?
Don't call me boss. I'm not your boss.
Yes, sir.
Judge,
When the judge asked you if you wanted a court appointed
It's just getting worse and worse by the second. Can you repeat that, boss? Oh, shit.
attorney, did you tell him yes or did you tell him no?
I told him yes.
Okay. All right. So more than likely somebody will be appointed to represent
God knows what he told him. He knows the first answer didn't work.
you tomorrow. They should go meet with you either on Tuesday or Wednesday. All right, sir?
Got you, boss.
All right.
you're awesome.
Have a good day, sir.
Yes, sir.
Pet peeve is
Did that dumbass do it a third time, or am I hallucinating?
when they call me boss.
On it. And if you would please state your full name, first and last.
Ashley Shanice Collier.
All right, perfect. May I please have Alan Lewis come on up to the table? All right, Ms. Collier, you there we go. You were here on time for court today. Is that correct?
Yes.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes,
Did you understand those rights?
I do.
Any questions I can answer for you about any of those rights?
No.
Ms. Collier, you have passed up to me this self-represented defendant plea rights waiver. You recognize this document that I'm holding up?
Yes.
Do you recognize it as the written version of those rights I read out earlier?
Yes.
Are these your initials next to each of the lines on page 1?
Yes.
Page 2?
Yes.
Is that your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And did you understand everything that's on it?
Yes.
Did you see where it says you have the right to have an attorney represent you?
Yes.
And you're here representing yourself?
Yes.
Is that what you want to do?
Yes.
You understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial. This case will be closed. Is that what you would like to do?
Yes.
All right. You are charged with 1 count of disorderly conduct, which is a reduced charge from your original charge, and that you did commit the offense of disorderly conduct on 1/8/25 here in Spalding County by acting in a disorderly manner in the presence of Kelvin Allen in a manner that threatened the immediate breach of the peace. Did you do that?
Yes.
All right. I find with your admission of guilt, there's enough for me to take your plea. I find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I've reviewed the recommendation. I'll follow it exactly the way you've negotiated. Do you have any questions for me about anything before I sentence?
So after the community service and everything is completed, will there be some stuff on my record? Like I'm really trying to get into pharmacy school and I don't want anything to hinder me.
So the answer is yes.
Then stop breaking the law, asshole.
Yes, there will be a conviction on your criminal history for disorderly conduct. If you wanted to avoid that with me, the option would be today to use first offender, but that's a huge, you're welcome to do that if you want. You're also welcome to stop the plea and to let me reset you for you to talk to an attorney to see if there are other options on the table.
Yeah. See, this would be a really good question for an attorney. Like before you enter a plea. That's how you do this.
Other than this plea. I'm just saying we're almost about to shut that door, but we haven't shut it quite yet. So this is your last chance to, I'm mixing all these metaphors, but this is your last chance to bail out before I close the door.
Right.
So whatever you want, you're still in the driver's seat. So whatever you want to do is what we're going to do next. If you want to go forward with the plea, we go forward with the plea. If you want me to reset you to a trial calendar to let you go talk to an attorney or get the public defender's office.
I mean, he's self-aware, but this judge really is a metaphor blender over there. I mean, he's gone about 6 different ways.
And we're going to go in that direction. So I'm not steering this ship quite yet.
I know you guys don't have really much time for this. But,
No, I just want to make certain that that you have the information you need to make an informed decision about what you want to do. And I'll go ahead and tell you, if you're not sure, then if you go forward, like we're done and you've
Yeah.
made a very final decision. If you are not sure, we need to reset this and give you time to think about it.
I'm sure I'll go with the plea.
Okay. Do you want to use?
Oh my God. Not only are you not going to get into pharmacy school because you have a conviction, you're too stupid to get through pharmacy school. That much is clear to me. You have to be smarter than that to do it.
Use the first offender. I mean, very rarely do folks use first offender on disorderly conduct, but you could.
Yeah, and
I don't know what
want
pharmacy
to-
school is going to do with it.
Yeah, that's what I'm saying. I don't want to use that on something low like that.
Okay.
So no.
All right. Well, then, with your permission, I'm going to go forward. But I'm just telling you that this really is your last chance to say, time out. I'd like to reset and try again on another day.
Okay. So no, I'm okay with my decision with the plea.
Okay. Then we're going to move forward.
Okay.
All right. Here we go. All right. Well, then I'm going to find with your admission of guilt that there's enough for me to take your plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I reviewed the recommendation and I'll follow it. I'm about to sentence. And when I finish the sentence, we're done. Do you understand that?
Yeah.
You're ready for me to sentence?
Yeah.
That was a pause and a lean and a tentative. Yeah, I need you to be decisive. So, because in about 10 seconds, I'm going to decide for you. So what do you want to do?
I want to talk to somebody.
That's a good call. All right. If I would have decided for you, that's exactly what I've said. So just so you know, what you just said was exactly what I was about to do. So, all right, let's do that. All right. We're going to reset you. And I'm going to put a note here that you are worried about pharmacy school. Did you talk to the solicitor's office about that?
I didn't tell.
Oh, come on. That's not happening. But seriously, sweet judge. He's sorry making a mistake. He was going to let her, actually wasn't going to let her do it. But he did everything he could to hint to her it's a bad idea.
Tell her that. No.
Yeah. So you felt like that was not part of the calculations they made. So, all right. So if you will please step back and over to the light switch. I want you to go to the public defender's office today. Oh, they make everybody go that way now. If you want to know why you have to go that way, go to YouTube and look up guy jumping over the bench. And ever since that guy jumped over that bench, they make everybody go that way. It's pretty impressive, scary video. The reaction from the crowd says that y'all have all seen it too. So, okay, ready? All right, Lewis, come on up and.
Perfect. So.
Hello, sir. May I have your name, please?
Alejandro Aitan.
Okay, Mr. Gaitan.
Yes, ma'am.
Hold on, let me just look. You have you're currently under arrest, and I'm gonna set the bond on these two cases. It's warrant number D25-08239-2, possession of a controlled substance, penalty group 2, less than a gram, a state jail felony, and D25-08239-1, which is manufacture delivery of a controlled substance, penalty group 1, over 4 grams, less than 200 grams, which is a first degree felony.
See, this guy's a pharmacist right here.
And on the first degree felony,
pharmacist.
which is the over 4 grams, less than 200 grams, I'm going to set a bond of $75,000 surety. You will be under enhanced supervision for both. And on the possession of the controlled substance penalty group 2, a state jail felony, I'm setting the bond at $10,000. The conditions of your bond on both is enhanced supervision, curfew from 9 p.m. till 6 a.m. No illegal drugs or alcohol. You will be subject to biweekly urinalysis. You shall not leave El Paso County without permission from the court. You shall not commit any new criminal offenses. You shall not possess weapons or ammunition. You shall report your place of residence and not move without court permission. And you'll be screened by OSAR and Tacoma. Thank you, sir. Good luck. Yes.
What's surety? Like, what's that?
That means that it's a bond. It's not a PR bond. There's two kinds of bonds: surety or PR bond.
So I'll have to pay. What's my total bond?
$85,000.
$85,000. Okay. Okay.
You got that jingling around in your pockets? 85 grand. As a street pharmacist, he might.
And you said I can't. I have because look, if I pay the bond, I work. I have my job. You know what I mean? You say 9 to 6 p.m. I yeah, I work.
Where do you work?
I work in Denver.
What's your work? What's your job?
I do skylights. I'm gonna start a project on December 1st right here on Oregon Mills.
Okay. And you do it at night?
No, you're not.
Yeah, we were gonna work all day long, every day.
You can work all day long or every day. You have a curfew from 9 p.m. at night till 6 a.m.
Oh, okay.
It's just it's a night curfew. I don't see you guys unless you're working nights and even
No. Okay, I had it misunderstood.
Yeah, there you go. But anyway, good luck to you, Mr. Gaitan.
Yes, ma'am. Thank you.
You're welcome. Bye-bye.
Okay.
Hello. May I have your name? Hi, may I have your name, please?
I'm Tara Atkinson.
Okay, Miss Atkinson. Hold on, let me just look. Miss Atkinson, you're currently being held on 3.
This one is special. Oh, yes.
warrants. They are Jail Mag 25-12466, which is possession of a controlled substance, penalty 1/1B, less than 1 gram, a state jail felony. Then you're being held under Jail Mag 25-12253, credit card or debit card abuse, a state jail felony. And then Jail Mag 25-12254, credit card or debit card abuse, another state jail felony. And I'm just here to tell you what your bond is for those 3 cases. So I'm going to set the bond for each one at $10,000 surety. So it's $10,000 surety for 12466. It's a $10,000 surety for 12253 and a $10,000 surety for 12254. The conditions for all of those 3.
She is understanding none of this, as you will see in a minute.
3 bonds. You will be under enhanced supervision. You'll have a curfew from 9 p.m. until 6 a.m. You may not use any illegal drugs or alcohol. You will be subject to bi-weekly urinalysis. You may not move. You shall not leave El Paso County without permission from the court. You shall not commit any new criminal offenses. You shall report your place of residence and not move from your place of residence. You shall not possess weapons or ammunition. You will be screened by Osar Tacomi. Good luck to you, ma'am.
But does a PR bond give me if I talk to the PR bond, can she get me to a home?
So there's no PR bond. It's a surety bond on all 3.
So what does that mean?
That means that you have to talk to a bail bondsman and you have to put up the amount that they ask you to on all 3 of them.
So you can't give me a PR bond?
No, ma'am, I can't. No, you're already out on bond.
Yeah, why can't I go get reinstated on bond?
Because you're already out on bond.
So I have to stay here?
How much you bond out?
How much is, I don't understand how much is.
To give you the bond amount.
May I have your name, please?
Yes, Your Honor. My name's Amy Chavez.
Okay, Miss Chavez. You are currently being charged with theft of property over $2,500, 2 more previous convictions under Jail Mag 25-12197, a state jail felony. I'm setting your bond at $15,000 surety, and you will be under enhanced supervision. You will be subject to a curfew from 9 p.m. to 6 a.m. You may not leave El Paso County without permission from the court. You shall not commit any new criminal offenses. You shall report your place of residence and not move without court permission. You shall not possess weapons or ammunition. Good luck to you, ma'am.
Your Honor, I'm sorry.
Yes.
There's no way you can give me a PR bond? I've never had a PR bond. I have a 3-year-old and a 4-year-old that need me right now. They're gonna go to CPS, please, ma'am.
I wish I could, but given your criminal history, ma'am, I can't.
Yeah, you see, you're supposed to think about that before you commit the crimes.
Okay.
I'm sorry. Good luck to you.
Just give me an info.
Hello, are you Mr. Callahan?
Yes, ma'am.
Okay. Currently, sir, you are being held under 2 warrants.
Now this guy completely gets it. Like he knows too much. That's actually more disturbing.
The first one, D25-08197-2, is possession of a controlled substance over penalty group 1/1B over 4 grams, less than 200 grams, a second degree felony. And warrant number D25-08197-1, which is possession of a controlled substance, penalty group 1/1B, less than 1 gram, a state jail felony. And I'm here to set your bond on the first warrant, which is the second degree felony. I'm setting the bond at 30,000 surety. And on the second warrant, which is a state jail felony, I'm setting the bond at $10,000 surety. That'll be under enhanced supervision. You will be subject to a curfew from 9 p.m. to 6 a.m. You must not use any illegal drugs or alcohol. You will be subject to biweekly urinalysis. You shall not leave El Paso County without permission from the court. You shall not commit any new criminal offenses. You shall report your place of residence and not move from that place of residence without court permission. You shall not possess any weapons or ammunition, and to be screened by Osar Tacomi. Good luck to you, sir, Mr. Callahan.
Hey, yes, ma'am, Your Honor. They have the weight on that wrong, and is there any way that it could be weighed again?
Once you have an attorney, you're more likely than not, I don't know, be appointed an attorney. And once you have an attorney, that's something that the attorney has to do and request. I can't do anything about that right now. We're just here for the bond. And I think you also have, looks like you may have a detainer from Alabama.
Yes, ma'am. It's a detainer for community corrections, but yeah, the weight on that's like 3 grams off.
All right. Well,
for sure.
I know. I was carefully packaging them for resale. He's probably right too. That's the worst part.
Say you're the expert. I'm not.
Right.
Good luck to you, sir.
Thank you, ma'am. Have a good day.
You too. Bye-bye.
I believe that was it, Judge.
Thank you. I appreciate it.
When you look at shoes, in case of Fashion State of Ohio versus Leland, the Atwater case number 25 CR 001313 for purposes of arraignment, and on case number 25 CR 000127 for purposes of sentencing. Defendant is present with his counsel today, Ms. Rachel Smith. On case number 25 CR 127. We were last here on July 8th, at which time the defendant entered a written and oral plea of guilty to failure to comply with order of signaling a police officer, felony of the 4th degree in violation of 2921.331B. Count 2, operating a vehicle under the influence of alcohol, a drug abuse, or a combination of them. Misdemeanor of the 1st degree in violation of 4511.19A1A. We were originally set for sentencing on August 25th of 2025. The defendant did not appear. As a result of his failure to appear on 2 separate occasions, case number 25 CR 001313 was filed, and that is 2 counts of failure to appear, felonies of the 4th degree in violation of 2937.99.
All right, we're going to deal with case 25 CR 1313 first. This matter is scheduled for an arraignment. Mr. Atwater, did you receive a copy of this indictment charging you with the 2 counts of failing to appear?
Yes, Your Honor.
Have a chance to look that over?
Yes, Your Honor.
You have the right to have me read that indictment to you, and I'll do that if you'd like me to, or you can waive the reading. What would you prefer to do at this time?
Waive the reading, Your Honor.
Very well, then as to those 2 counts, how do you plead at this time?
Not guilty.
All right, the court will enter a plea of not guilty. And I'm going to set bond at $10,000 cash surety. All right, now in regards to case 25 CR 127, Ms. Smith, is there any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Is there anything you'd like to say on behalf of your client?
I would, Your Honor. Mr. Atwater is before this court on a failure to comply case. Mr. Atwater is
a veteran. He served in the Marine Corps. He was twice deployed, suffered a traumatic brain injury from that was documented from an explosion. Prior to finding himself before this court, he was established with services with the VA, attending once a month and working on obtaining a therapist. Your Honor, Mr. Atwater's PTSD kicks in as fight or flight, and for him, it registers with flight every single time. It's how he came before this court on the underlying offense. It's how he came to flee his sentencing hearing. But he was re-entering the country from Canada after fleeing to see his family for the holidays and then turn himself in. Obviously, he was unable to complete the first part, but he is before the court, humble and apologetic. Mr. Atwater understands that under the laws of this state, the court has no option but to send him to impose a prison sentence in this case, despite the fact that at the change of plea, it was offered that there was a joint recommendation for community control in this case. Mr. Atwater also pled guilty to an OVI. His drinking is as much tied to his service and his resulting disability. And despite being incredibly intelligent, incredibly respectful in most of his dealings with individuals, although not in complying with.
Okay. Are they doing it? Seriously, I got to know. Inquiring minds have to know.
This court's orders. Mr. Atwater understands the court will be imposing a prison term today. He would like the court to consider the role that his PTSD does play in each of both the offenses to which he's pled guilty and the.
No, you're asking me just to assume that. I have nothing about that. I gave him an opportunity to provide me information on that, but he chose not to do that.
And Mr. Atwater understands that the only reason that the court is very likely imposing a prison sentence here is because he has made it. So the court has no other options.
But my point is, you're offering these explanations, and I guess I'd take your word for it, but I don't have any.
Am I allowed to speak, Your Honor?
You'll give a chance in a moment.
And Your Honor, that is the purpose of a pre-sentence report, and that's why it was critical that it take place here. It did not, and it did not because Mr. Atwater did not appear. And so, Your Honor, we are asking for leniency in the prison sentence that is imposed. Mr. Atwater does not have a criminal history. He does have a record of service with this country as a veteran.
Yeah, we know. We know all about it. But he fled. That's bad. You're not going to find anyone who appreciates his service more than me, honestly. But he fled. This is actually a good thing. He came back because now he has to face it. It's good. They pick him up when he tries to come through customs. He's got to clear this out of his life and figure his life out. I'm actually happy to see it, but that's not like, oh, okay, well then you can just get wasted and run people over. Nope, that's not how that works.
I believe that he intends to indicate his remorse and regret to the court in his own words as well.
Thank you, Ms. Smith. Mr. Atwater, you have the right to address the court before your sentence. You can say anything you want. Is there anything you'd like to say at this time?
Your Honor, I'm deeply apologetic for the decisions I've made, and this is the most trouble I've ever been in my life, and I've never. A lot of these terms are very new to me. Please, just the whole situation is I was completely oblivious to. So,
probation by 9. That's confusing?
Not confusing, just wasn't feasible, Your Honor, because there was.
And you should have stayed in jail. I gave you a bond because you told me you'd be able to do it.
You know, I have this is the most time I've ever been in jail. It's a terrifying, scary situation. I have kids. I've never been away from them besides the time of me being at war. And I felt like the time I had spent in jail was worse than war. Like it completely was. I don't have anything as far as like to say. When I said I could show up, I was planning on finding a way. My mother was out of town. She was in.
I mean, this poor guy. So far, what I know about his life is we've got war, jail, Canada, and Ohio. That's rough. I'm feeling bad for him.
Another country, and I was just under the influence. I wanted to get out of jail at that time, and I tried to find a way, and it didn't work out in my best interest, Your Honor. I'm apologetic about that as well, and I just want to say I don't go out with any ill intent of doing harm to nobody. I don't stole from anybody. I don't like be in the world doing anything wrong. Most of the history I have is just driving. The one thing I did on that instance in January, all I was doing is trying to avoid a confrontation at home. I went to the bar, I drove home, and that was in this situation ensued. There was no craziness as far as like I'm not out here doing anything wrong. Just trying to raise my kids. I'm taking my kids to football games, cheerleading practice, you know what I'm saying? The normal dad stuff, and just try to live in the world as peacefully as I can. I've been in 3 different trade schools. I do home renovations. I do a lot of different things to not be in trouble or getting in this type of situations. That night was me trying to avoid a situation, and it happened to be this is what happened from it. So I apologize for just the whole situation in totality.
All right, thank you, sir.
Thank you, Your Honor.
Smith, anything else?
He is a likable guy. I will say that. He's a likable guy. But just do your time, pay your debt, and knock it the hell off.
At this time as to this matter, Your Honor.
1 second. Oh, Ms. Linden, on behalf of the state.
Thank you, Your Honor. Your Honor, I know we did originally say that we were going to find recommendation for community control, but the problem is that we're going to show up. And it's clear that that is a difficult thing for the defendant to do for whatever reason. So if the state is recommending a prison term on this matter, he does have 8 days of credit for time served. There is a requisite driver's license suspension on the failure to comply of 3 to life, and then on the OVI of 1 to 3 years. There's a mandatory 3 consecutive days for the OVI, and then a mandatory fine as well. So we'd ask that you impose those. Thank you.
Thank you.
Your Honor.
Hang on 1 second. Smith?
Your Honor, it's my understanding that Mr. Atwater has 8 days of jail time credit since his arrival.
Yeah, that's exactly what I'm doing right now.
Okay.
We live do you have a number?
I do not, but there were, based on my records, it appears at least 3 other times.
He's been in jail several times.
Yes.
It was the original jail time was from November 22nd to November 24th.
January, you mean?
Sorry, January 22nd. I'm sorry, January 22nd and January 24th. Then after that, from July 7th to July 8th, and now he was arrested here on the 24th, is in custody and until today's date. That's where I came up with 8 days.
He was arrested?
On this case?
Yeah, and now, recent?
Now, 24th.
That was the date of arrest or the date he arrived in the jail?
I have from
what date were you detained at the
Deputy Robinson from the Marshal apprehended on the 24th.
Okay.
Was in custody.
Let me look at something first. I mean, looking at the docket, I mean, his bond's been revoked 4 times in this case. So back in February of this year, there was a motion to revoke his bond that was granted. The warrant was issued on February 19th, executed on the 20th. So he was arrested on February 20th. Then there was a hearing on a motion to reinstate. And the judge reinstated it at that time, but that's 5 days there. 20th, 21st, 22nd, 23rd, 24th. So that's 5 days in February, 3 days initially. Then the next month, a motion to revoke bond was granted. He was arrested on March 31st. Motion to reinstate was filed. And that was granted on April 8th. So the 31st through April 8th, he was in jail. That's 9 days. He was arrested on the 7th because he showed up late for the change of plea. We got him in the next day for the plea, correct? On the 8th?
Yes.
That's when he was released. So it's the 2 days you have there. And then you're saying he was arrested on 11/24.
Yes.
Till today. 3 more days.
22 then.
I don't know yet. 14, 16. We got 20. Am I adding wrong?
3 original, then 5 plus 9, then another 5. 22.
Oh, yeah. 22. All right, this court has considered the facts and circumstances of the offenses involved here, the nature of the offenses involved here. Consider the history of this case. I don't have a pre-sentence report to review as an neuropsychological evaluation that were ordered by this court as the defendant failed to appear at the probation department to assist in the preparation of those reports, which would benefit him, benefit the court. I've considered everything that's been said here today by Mr. Atwater, his lawyer, prosecutor. All this is considered only the purposes and principles of felonies. I'm sorry. Felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually in regards to the stated factors. However, the court will note that for the fleeing and eluding charge, the defendant was operating the vehicle under the influence of alcohol or drug abuse at that time, which makes the fleeing charge more serious. Nothing makes it less serious. As for recidivism factors, the court notes, well, the defendant may not have a criminal history, has a horrible traffic history with multiple driving under suspensions, which this coincides with the conduct here throughout, just not following rules and not following orders and court orders. And he just does what he wants to do. Appears to be an alcohol problem, at least related to this offense, and isn't anything to address it. I don't find genuine remorse. Again, I could find genuine remorse just coming here today and saying I'm sorry, but the conduct and your behavior leading up to this shows no remorse. And other factors indicating relevant factors, just the fact that the defendant's bond has literally been revoked 4 times in this case. Sit down, please.
Yes, sir.
First 2 times is because he wasn't able to pay for whether it was Scram or GPS, I don't know which one it was. And it was revoked and reinstated. And it got revoked and reinstated. And in this case, he shows up late for his plea, so it was revoked and reinstated. I've never seen that happen before. So if they're bond revoked 3 times and then been reinstated every time, that's part of the problem here. You think you can just do what you want to do and you're going to get what you want, and then I'll end it. And then it was violated, revoked again because the defendant, when I reinstated it, when he got reinstated for the 3rd time, he was told to show up the next morning by 9 a.m. He didn't show up. Didn't call. Didn't come the next day. Didn't reach out at all. Said you didn't have a ride. But nobody knew that. You didn't call anyone to tell him that.
I was under the influence. I was going to jail, Your Honor. That's all.
That's not an excuse.
It's not an excuse. And I feel like there was a lot of miscommunication with the scram writer because they said they was going to pay for it, and then I got bound over Lake County, and then they never told me that I had to pay for it. That's where all that miscommunication came from initially for the scram.
Even the second time?
Yes.
When you got revoked and again it was reinstated, and you said you would pay for it?
I was paying for it, Your Honor, but they didn't tell me that I had to pay for it. It was a surcharge every day. So I was paying for it weekly, but by the time I paid for it the next week, they were saying that I was late. That's what that was about.
I know what it's about.
I didn't know that I had to pay for it ahead of time.
You keep saying you don't know this stuff, and this stuff's explained, but you just don't pay attention or you don't want to hear it. You claim I didn't know I had to be there by 9 o'clock, or maybe it was your girlfriend who called here. Your girlfriend that called here and said it was never told what time he had to be there on that day. Well, that's...
I know I had to be here at 9 o'clock, Your Honor. I just didn't have a ride. From Cleveland.
Bond's been revoked 4 times. You've had multiple license suspensions because you just do what you want to do.
All I've done was go to work, Your Honor.
I gave it up. You say what you want to say because it's my turn to speak, but apparently you have more you want to say. So I'm going to let you say what you want to say, but then it's going to be done. We're not going to go in this debate here.
Yes, Your Honor.
Is there anything more you want to say?
No, Your Honor.
So his bond was reinstated when after he showed up late for the plea. Didn't show up to any of his appointments, didn't call, reach out, didn't do anything. Showed up for his sentencing, and he left. And he's been gone September, October, November, over 3 months. 3 months.
Terrible person on him.
Attempted to leave the country.
Never left the country.
I said attempted to leave the country. We're not having a debate. I said attempted to leave the country. You're going to leave the country.
Never attempted to leave the country.
Your attorney just said it. And I knew you were arrested or someone trying to get near the Canadian border.
No, I was not, Your Honor. That is false information. I was arrested at home. I don't know where Canada came from.
From your lawyer's mouth.
It's relayed to me by the state. I can tell you from what the marshal said. So in terms of...
You're going to be removed from this courtroom if you're not going to keep quiet.
Yes, Your Honor.
I've given you every opportunity to speak. I've asked you multiple times if you have anything more to say. And I said, we're not going to argue back and forth. And you keep doing it. It's the exact history of what this case is about. That you just do what you want and don't listen to anybody. Mrs. Linden?
The information from Josh Robertson from Sheriff's Office indicated that they had to...
This is getting fun. I'm not sure, but I think this is the same place where Judge O'Donnell's from. So these guys have lunch. And there are cocktails involved.
Ping his phone, that they got the phone number that was pinging within 25-meter radius of Windsor, Canada, was across the river from Detroit. He had to reach out to Border Patrol to see if he's crossed over, and they were looking at a provisional warrant to give to Canada as a result of that. There was a Canadian counterpart that they were trying to get in touch with as well there. They were going to continue to ping the phone. And then he appeared to be the next day back in Detroit. And they were going to reach out to Detroit at that point in time. And
that's what I figured. This Jagoff, he came from Windsor to Detroit. There's 2 ways: there's the tunnel or the Ambassador Bridge. And they knew, but they didn't have it all together. So then they were just pinging him.
Then they continued to ping his phone, and then he was finally arrested.
Thank you. So again, there's a history here of not complying with the court orders and rules. As for factors indicating recidivism is less likely, the court knows the defendant doesn't have any criminal history, led a law-abiding life or significant he doesn't have a criminal history. I can say he's led a law-abiding life because he's got a horrible traffic history And that's not following laws or abiding by the laws.
I don't know this judge, but I like him. He was trying to be nice. He was respectful. He's like going with it. He's like trying. This hearing starts with him trying to help him to the extent possible. But I mean, he just kept getting the shim sham, and he finally had enough.
Again, the defendant failed to appear for a pre-sentence report, so I don't have a report that was completed, and thus I don't have the law, the authority to impose community control sanctions. When we look at the history of this case and what's this whole thing's about, there's no way the court can find the defendants amenable to community control sanctions. The very offense itself deals with failing to comply with an order of a police officer. Defendant's bond again was revoked 4 times in this case. The history here is that he doesn't comply, doesn't follow the rules, and he's going to do what he wants to do. So prison is consistent with the purposes and principles of sentencing. Therefore, it'll be the sentence of this court that on count 1, defendant serve a term in prison of 12 months. Count 2, he served 180 days. By law, that must be concurrent. So 12 months in prison, he has credit for 22 days he's already served. I need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed, which would be 6 months. Any additional prison term imposed for violating post-release control being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. There's a mandatory license suspension for both counts that's required. I'll suspend the defendant's license for count 1 for 3 years, which is the minimum. 1 year in count 2, there'll be a concurrent suspension. It's a mandatory fine in count 2 that must be imposed. I'll impose the minimum fine of $375. Defendant's also ordered to pay all costs. Is there anything else for the record, Ms. Linden?
No, Your Honor, thank you.
Ms. Smith?
Your Honor, only that in case number 25 CR 1313, Mr. Atwater has executed a waiver of speedy trial and bond condition. I think the
Okay, get that file. Thank you. Anything else?
Not at this time.
All right.
Mr. Hornick is present today with his counsel, Dan Getty. The state is represented by Brian Goodyear. We are here for sentencing.
Okay, we got another DUI that I had. This is from Court Cam. It's old, but it's good. I hadn't seen this nugget before. This guy's way more annoying than the last defendant.
Is there a statement from the state of Ohio?
Yes, Judge. As you know, Mr. Hornick at least has to serve 120 days in jail on this case because it is a high-tier offense. I would argue, Judge, that what should happen is that rather than serving the minimum 120 days, that Mr. Hornick should serve a term in prison. And the reason for that is that, number one, he was on active probation for an OVI when he did this. Obviously been a consistent history with him since 2017. He has a conviction of OVI 2017, 2019. So he was still on probation for the 2022 case when this happened. And so he's had multiple.
I like this prosecutor already. He's in the Regier camp. This guy.
Opportunities to try and get some type of help for the problem he has. If I remember looking at the PSI, he says he considers his drinking problem, I think he gave it a 2, so minimal or slight, although he indicated he drinks 12 to 15 beers each day. So I think he, despite having obviously many interventions regarding his alcohol use, it has not impacted his viewpoint of himself or his behavior. And then in addition to that, Judge, I would point out.
Wait, are we counting the 12 or 15 beers? I thought that's just regular hydration, I think.
That we're not talking about a speculative danger that he causes to the public. In this case, he ran a red light and 2 cars struck him as a result. And it is just by sheer luck that he was pulling a trailer. They hit the trailer he was pulling and did not injure him or themselves. but there was a motor vehicle accident that occurred because he was too drunk to stop for a stoplight. So we're not even talking again about some speculation about he is a danger. He could have easily killed people that day. So from the state's perspective, someone that is in this situation still clearly doesn't comprehend the situation that he faces and creates this risk. The only real answer is a prison sentence. So we would ask the judge that you sentence him to prison.
Mr. Getty, anything on behalf of Mr. Hornick?
I would just argue that the 120 days, he's done 67 now. He's going to end up doing 120 no matter what. Yeah, he's had opportunity. I think this court is well aware with alcoholism, it's a reoccurring thing until you finally fix it. He's been punished in this case. I think the purposes and principles of sentencing would indicate that you should sentence him to punish him and not to over-punish him, but then to rehabilitate him. You have all the power to rehabilitate him with the 120-day sentence. The 120 days is quite a long time. He's never served that amount of time in jail on his OVI offenses, nor been punished in this manner. So we'd ask the court for the minimum mandatory sentences on this, Your Honor. Mr. Hornick may have something to say.
If I may.
Go ahead, sir.
Thank you. I don't understand what the number 2 was on that. I full of credit. You'll see my rating that I don't understand that my saying that alcohol is only a number 2 problem out of whatever. I don't recall that. So I must have misread it. I take full responsibility for I need to recovery. So let's just get on. I just wanted to say, Your Honor, thank you for allowing me to speak. I know time is of the essence, so I'll roll through.
No, he doesn't. Now that I think about it, he's just like the last one. He's just like the last one. He can't take responsibility. That's it. That's pretty much criminal defense in a nutbag, in a nutshell, right there. They can't just own their actions and move on. Always a victim.
Well, wait just a moment, because don't rush her through this for a couple of reasons. One is she's got to take this down. Okay, you're nervous.
Just scared.
Yeah.
Well, he is a nutbag.
Be as calm as you can and go through it slowly.
Okay. I feel devastated, broken, and crushed. I am terribly remorseful for the breaking of trust and hearts I've caused of the people closest to me. On top of this, I've caused a promising upstart business to fail in my absence. As for my experience to date in jail, it has been the most unraveling, frightening time of my life. I have seen what a life of lost hope looks like. Fights, threats, nonstop yelling. It's like Lord of the Rings. The number of people have holds and who are coming from other places, it befuddles me. It has been jackhammered into my head, into my soul, that God did not make me to follow this path. I found what little hope I had left in myself and surrendered myself to Christ. This time, on my knees in misery, as opposed to the first time in total joy. I set my jaw towards regaining my relevance, usefulness, and trust in this life, especially with my 5 absolutely fantastic children. And that's 1 baby mama. Number 2, I voluntarily checked myself into a full recovery program at Woodhaven for the full program.
He's proud that that's 1 baby mama. He is the quintessential low expectation MFer.
In the past, I have completed partial programs, insurance usually being a factor there. We're talking months of rehab, not weeks as before. 3, I have home groups in AA and Celebrate Recovery, which is wonderful. I have a sponsor in one and a mentor in the other, and another gentleman here from AA who's from the jail AA group. Well, thank you for both gentlemen for being here. 4, I began a daily prayer and Bible reading schedule. That is my alone time for introspection. 5, I have finally forgiven my ex-wife for what she has done to me for 30 years. This is absolutely crucial to my recovery. 6, or just 7, I consulted with my doctor.
Yeah, we don't care. We don't care. Like, all those things might be relevant to your little internal journey, but right here, what we want you to do is shut up and follow the law. Like, those things might be meaningful to you. I'm not knocking that, but we don't want to hear about it.
We're working through some anxiety problems I have anyway, which was part of my drinking problem, and the other was my wife. Now, once I arrived in jail, I threw myself into as much constructive activity as I could. One, I consistently attended life skills, AA, church, and A&D education sessions. I have tons of handouts, personal notes, and booklets, including the AA book that the gentleman behind me gave me, and I read it through and highlighted every page that was important to me for the first time. 3, I formed a game plan for employment. 4, I've written out my life goals for 1 month, 6 months, 1, 5, and 10 years. Number 5, I've read 22 books. I don't know why. And 6, I worked as best as I could, or I worked out best as I could, 2,200 steps a day up only. An inventive upper body workout, which is kind of hard to do in a facility like that, but every other day. Looking forward, my dearest hope is that I will make the best rest of my life, continuing through today, not languishing in jail. I am so fortunate to have a furnished home with a family, things, and memorabilia, and an improving relationship with my children. Woodhaven is only a couple of miles.
How? While you're not working or contributing in any way. Oh, this guy just makes me sick. He really does. Or like he thinks, like, my goal is to do the best I can with the rest of my time. Yeah, you and everyone else on the planet, Jagoff. Do you think you're special? Just shut up and follow the law. That's all we're asking.
Away, my hope is to finish my sentence, possibly at home monitored, so I will be able to use the best of my time attending AA and CR meetings online, doing a 90 and 90 online, which can be documented for the first time.
Oh, this hearing's old, so you probably did see it somewhere else.
I've never done a 90 and 90 days, and I stand a good chance of another part of the house, and I stand a good chance of losing it if I can't get, or having it broken into, because I'm the only one there. It's a beautiful house, but it's not in the best of, in a depressed neighborhood, let's put it that way. I have a comparison and 2 quotes I'd like to best describe my mindset going forward. 1, I don't want to.
You're kidding me. The house is in disrepair because you have 5 kids over there and nobody to maintain it. I'm shocked. Seriously. You know what? I've got a plan. Maybe stop breaking the law and do what you're supposed to do as a father.
Recover to my old self, but transform into a new me. Not unlike, and this goes right to a friend of mine who wrote a book on this, a children's book has written. Transform into a new me, not unlike a caterpillar turning into a complete mush, which is where I'm at now, in its cocoon, or as we call it, the chrysalis stage, to emerge in time as a butterfly. Sounds kind of flowery, but it fits. Number 2, I came across in one of the books I read a Mark Twain quote I'd never heard before. He said, the 2 most important days of your life are the...
He wants to be a butterfly. I can't take this shit. I can't say what I want to say. Y'all know what I want to say. Y'all know what I want to call him. It's okay. Looks like the chat's covered me.
The day you were born and the day you found out why. That stuck. It had nothing to do with the rest of the book much, but that stuck with me. God, my family, career have always been the focus of my success. But there is something else missing. I want to find out before the day I die. And 3, finally, I still hope with all my heart that one day, as it's been said before by God, that God will say to me, welcome, good and faithful servant. Thank you, Your Honor.
All right, thank you, sir. This is your 5th OVI, right?
4th.
Okay, you got one in 2022. And okay, I want you to pay attention to me now.
I'm sorry, I'm just...
You got one in 2022. I could be wrong. That's why I'm trying to get through this. You got in Kettering, right?
Or yes, I'm sorry, yes.
Okay.
I'm a little out of sorts.
You got one in 2019 in Delaware.
Yes.
Okay. You got one in Oakwood in 2017.
I don't recall that as being an OVI, but I'm listening. I'm not sure if you're looking
you
at
know
your,
what?
your what response or not.
Yeah, it was.
I don't even know where this court is. If anybody knows, tell me in the chat. I don't even know what state it's in. None of these places sound familiar to me.
OVI Brett in Oakwood, you failed the Brett test. That's typical. You get charged with driving under the influence and over the limit. You pled to the over the limit. Okay, that's 3, right?
Ohio.
Yes or no?
I hear yes, Your Honor.
Okay. And then you got one in Lyndhurst in 2017, right?
That was the Delaware one.
7/28/17. This says 12/26/19 for Delaware, the day after Christmas.
I'm confused about that one.
He's just trying to determine if you 5 OVIs. It sounds to me like you just don't remember some of them.
I would think I would, but
Okay, let's.
I don't want to contest you. I'm
just trying to make sure I've got the right information.
What he's trying to do is make sure he knows the right stuff, so he's not charging you or sentencing you to something that you don't
I
have.
recall coming into here, I was told by the court, I guess, whoever, representative of the law, that I had 4. And so I've been having, I'm not thinking about how many, I'm not thinking about the other, I haven't been thinking about that. So I've had 4 in my mind. That's a lame excuse, but I just don't remember.
4 priors before this one. This is the 5th one, right? That's what I'm trying to establish.
It sounds so.
Okay. Now, I want to read something from the statute. What is necessary to fulfill the purposes and principles of sentencing? One thing I have to consider is just punishment, deterrence, and the big one, protection of the public. That's what sentencing is all about. And I don't want to say you talk a good game, because that's not an appropriate word, and I know you're serious. But you're pretty good at reading, studying this, but you haven't been very good at putting it into action, that your sobriety. I believe you and I can agree on that, right?
It's been a challenge given the life events that precipitated it. But those have been played to rest.
Okay.
The big one.
In other words, it's not my fault.
There's a lot to say about denial. I noticed you said, I forgive my wife. Well, this is about you. Your wife had nothing to do with this OVI. You're saying, well, that she's been a part of my problems in the past, but she might disagree with that. I don't know. But this is about you here today and your sobriety. Okay. And I don't know how I could look at anyone and explain why you didn't go to prison if you got out and number 6 killed somebody.
You couldn't. So throw the book at him, Judge.
That's my issue here. That's why I'm finding that you're not amenable to community control, and that a prison sentence is necessary to fulfill the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. Probation would not adequately punish in this case, and it would seriously demean what happened in this case. Therefore, I order you to serve a term of 12 months on count 1 and on count 2, 90 days, these two are to run concurrent with each other. Your driver's license suspension, okay, your driver's license suspension is 5 years.
Judge-
Fine, right?
Yes, he has a $1,350 mandatory fine.
Okay, so that's imposed, $1,350 fine. Mr. Getty?
I just want to make sure, or ask the court that they'll keep the option if we file for judicial release, that they'll at least give us that option and not have a closed mind in the state as well.
That's an option he has.
I know. I'm just throwing it out there, Judge.
Okay. Sir, you have a right to appeal this sentence. You have 30 days from today to file a notice of appeal. If you cannot afford an attorney will be appointed to represent you. Any document you need will be provided at no cost. Okay, that's all.
Thank you, Judge.
Yes.
Mr. Tebow, talk.
Ah, there you have it. He went to jail, but like I think that's like, I don't know. See, it seems like not enough, but it's a good stint. It's 12 months. We'll take it. Is it plus 90 days? I thought he said concurrent. I don't know. But that was hard. His little fairy diatribe was it was hard to take. It was hard to take. I think I lost testosterone just listening to it. Luckily I have extra, so it's all okay. Everyone relax. Don't worry about it. Thank you all for coming out. I'll see you soon.